least I can give my dissent. So, this voice of dissent has its own value. This voice of dissent has its own value. The dissent of Justice Khanna, sounded years ago, is now not only considered to be the law, as part of our constitutional amendment, but now we are acknowledging that Justice Khanna was right. The sitting in court will acknowledge. But this voice of dissent has its own value. There is some feeble dissenting TMFI. Let us hope and pray that ultimately the dissent becomes the majority decision. So all the judges have a duty. They must take the pledge to carry on their duty as a judge. I call it duty as a judge, not only their power. It's not a question of power, it's a duty as a judge. To exercise this duty in such a way that the constitutional promise becomes a reality. And this is very important that today you should take the pledge. As I have started by saying, the rich people in India should live simply, so that poor can simply live. Thank you for your attention. Supreme Court. Don't get startled by this expression, UK Supreme Court. Thank you. I request Lord Walker to give his presentation.
My theme this morning is the tension between two very important human rights. That is the right to freedom of speech and the right to reputation and privacy. Those rights are found in every constitutional Bill of Rights that there is throughout the world. I can say that without fear of contradiction as regards freedom of expression, possibly not with freedom of the right to privacy and reputation, but it is, I believe, increasingly being recognized around the world as a very important human right. My theme is not perhaps mainstream as regards equality, but I would suggest that it's not completely outside the stream of what we should be thinking about. Because whenever it is a question of balancing the right of one citizen to free speech against the right of another citizen to privacy, that is, I would suggest, one aspect of the problem of equality. Because these two rights are in tension, the right to free speech is not, I think, unqualified under any constitution or Bill of Rights in the world, with the possible exception of the First Amendment to the Constitution of the United States, which says in very bold and unqualified terms, Congress shall make no law which inhibits free speech. But even in the United States, that has not led to the US Supreme Court striking down statutes against sedition or obscenity or contempt of court. Though some decisions of the US Supreme Court, especially in the field of what they call hate speech, may cause a bit of surprise in other corners of the world. So far as the Constitution of India is concerned, the right to freedom of speech is conferred by Article 19 of the Constitution, as you all know, and Article 19 qualifies that right by reference to reasonable restrictions on the exercise of free speech in the interests of state security and other important interests which are listed, including decency or morality, or in relation to defamation. And the corresponding provision to be found in the European Convention of Human Rights is in Article 10, which again qualifies the right of freedom of speech by such restrictions as are prescribed by law and are necessary in a democratic society in order to protect various interests and aims comparable to those in Article 19 of your Constitution, including for the protection of the reputation or rights of others. The tension between free speech and privacy is not, of course, the only tension that arises with free speech, which is why all or virtually all constitutions do make it a qualified right. Because one citizen's right of free speech is to another citizen, or to the government, even to the government perhaps of a liberal democracy, either sedition or the disclosure of state secrets, think of WikiLeaks, contempt of court, blasphemy, obscenity, racial abuse, defamation, invasion of privacy. There are a huge number of different tensions, but it's the last one, the tension between freedom of speech and privacy and reputation, that I want to address. In English law, defamation has been recognised as a wrong for a long time. Indeed, in English law, defamation had its origins in the criminal law, and I have to say that the criminal offence of seditious libel, as it was called, was used as an instrument of oppression by governments in the past. And although it is an aside, I can't help commenting after Professor Kennedy referred yesterday to the battles for freedom in America, in Ireland, and in India, reflecting that great Irishman, Edmund Burke, in the 1780s, in the Claude British House of Commons, upheld the rights of freedom in what were then the British American colonies, and in Ireland, and in India. And it is a sad paradox that the French Revolution caused him to break with his old friend Charles James Fox, and instead to join William Pitt's Tories. And having been a great proponent of freedom in America and Ireland and India during the 1780s, during the 1790s he presided in something of a campaign of government repression in common with other of Pitt's ministers. But that's by the way. So defamation is a long-standing interest in UK law. Privacy is a much, much more recent occurrence. It has developed rather paradoxically out of the law of confidence as administered in the Court of Chancery, and it has emerged very much under the influence of our Human Rights Act, which has been enforced, as the Chairman said, since the 2nd of October in the year 2000. Perhaps it's not too parochial to mention the way in which the Human Rights Act has given the law of privacy a tremendous boost. When as Lord Leicester knows, when the Human Rights Act was a bill, and then when it had been passed as an act, but it was not yet in force, there was a very considerable controversy among legal scholars and among legal practitioners as to whether the Act operated only vertically or whether it operated horizontally as well. What I mean by that is that the principal way our Human Rights Act works is by imposing on on public authorities, which are widely defined, a duty to respect convention rights. But the court itself is a public authority. And so the question arose, was the court, as a public authority, under a statutory obligation, under the Human Rights Act, to develop the deficiencies of the common law in order to fill any perceived gaps as between one citizen and another, so that undoubtedly the Act operated vertically between the citizen and the state. Did it also, via the mediation of the courts, operate horizontally? And initially there was a good deal of scepticism about that, but then there was at least in the law of privacy, a very rapid development. And you can see it before the Human Rights Act was enforced, only just, and they failed. But against that, and the contrast is very striking because the two cases happen to be reported almost side by side in a few cases, is the case of Naomi Campbell, the celebrity supermodel. And she was not suing a public authority, she was suing the publishers of the Daily Mail newspaper. And because she was a supermodel with access to the best possible legal advice, she issued her writ on the very day the newspaper was published, whereas poor Mrs. Wainwright and her son only got public funding to issue a writ just before the expiry of the limitation period, which is why the two cases appear more or less side by side in the reports. But Naomi Campbell complained of a breach of privacy on the publication of a front page story, Naomi, I am a drug addict, accompanied by a large photograph of her leaving a meeting of Narcotics Anonymous in South London. She won moderate damages at first instance, £3,500. The Court of Appeal reversed that, holding that she had that the newspaper had a sufficient public interest in publishing the fact that she was a drug addict, especially as she had sought in public pronouncements to say that she was better than other models because some of them took drugs to keep slim and she didn't. And the House of Lords then, by 3-2, restored the decision at first instance, and she got her modest damages. There was no great there was no great difference in principle between the 3 and the 2 in the House of Lords. All of them agreed that invasion of privacy must now be regarded as an actionable wrong in English law. The difference was largely as to whether or not the Court of Appeal had been right to interfere with the decision of the first instance judge, which had attached particular importance to the large, and it could be said unnecessary, photograph of Miss Campbell leaving Narcotics Anonymous. As regards the new principle that emerged, it was very clearly put in the speech of Lord Hoffman, and it's paragraphs 50. Interesting that Lord Hoffman gave that speech because he was the only one of the House of Lords in Campbell who had also been in Wainwright, and in Wainwright he had said that there was no tort of privacy. So it shows how dramatically this new actionable wrong had emerged. And one of the principal authors, as a matter of the development of the law, was in fact Lord Justice Sedley, in a remarkable speech that he made in the Court of Appeal in the strange case of Douglas and Hello magazine, the one about the publication of the pirated photographs of the wedding of Michael Douglas and Catherine Zeta-Jones at the Plaza Hotel in New York, which is another strange episode in the development of our law. But what Lord Hoffman said, if I could quote it briefly, he said, what human rights law has done is to identify private information as something worth protecting as an aspect of human autonomy and dignity. And this recognition has raised inescapably the question of why it should be worth protecting against the state, but not against a private person. The result of these developments has been a shift in the centre of gravity of the action for breach of confidence, when it's used as a remedy for the unjustified publication of personal information. Instead of the cause of action being based upon the duty of good faith applicable to confidential personal information and trade secrets alike, it focuses upon the protection of human autonomy and dignity, the right to control information about one's private life, and the right to the esteem and respect of other people. The approach of the Strasbourg Court when these two rights come into conflict together is not to accord automatic precedence to one over the other, but to call on the courts to make a balancing exercise. The theme of balancing one individual's right against another and against the public good is a very basic theme indeed in the jurisprudence of the Strasbourg Court. And the English House of Lords considered just how the court should go about this in a case called Ries, which is also in the bundles. But Ries was a very unusual and very sad case in which application was made on behalf of a 5-year-old boy for the banning of any media reporting of the trial of his mother for the murder of his 9-year-old brother. So an extraordinary family tragedy. But the judge, as the Court of Appeal and the House of Lords held correctly, refused to make a ban. He said that of the public in the reporting of criminal proceeding, measures would need to be taken for his protection, but they were not going to include the banning of all reporting of the trial. And in giving that judgment, Lord Steyn, one of our great human rights lawyers who came to England from South Africa, emphasised again that it's not a question of one right having precedence to the other. It's a question of the court inquiring very carefully into the facts and weighing up the interest of, on the one hand, of the press or whoever it is in publication, on the other hand, of the individual or individuals concerned in privacy. That process is sometimes called in the courts or in the textbooks in England a parallel analysis. I'm a bit dubious about that because parallel analysis sounds as if it's a rather special technique, a scientific technique which is always going to yield a particular answer. It isn't. It is simply a label for the careful evaluation of the competing interests that the court has to make. Always judgment is going to be needed. And I would say, and this is a point that the press has made repeatedly, because the Human Rights Act is not that popular in the UK, that we are, as the press frequently reminds us, unelected judges. We have a good deal of experience and expertise in some human rights issues, such as fair trial. But when it is a question of balancing freedom of speech against privacy, we don't really bring any specialised training to bear on that. What we bring is a respect for both of those human values and common sense and an attempt to do our best to carry out that process of evaluation. It is one that Parliament has cast on us. It is the judge's duty to perform it, and it's our duty to give the best reasons we can for the reasons that we arrive at. The test that has been followed in England for whether there is a right of privacy It is whether, in all the circumstances, the individual has a reasonable expectation of privacy. I have to say that is such a vague formulation. It's really one way of, it's simply another way of posing the same question. But we have rejected the rather more demanding test, which has found favour in Australia and New Zealand, of what is highly offensive to a reasonable person of ordinary sensibilities. Our test for privacy is, it seems to me, set rather lower than that, but subject always to the possibility of an invasion of privacy being justified in the public interest. The public interest means what there is a genuine public interest in the disclosure of. It doesn't mean what the general public is interested in, because the general public is, as we all know, hugely interested in gossip and scandal. But the point has repeatedly been made that the public interest does not mean what the general public is interested in reading in Hello Magazine or wherever else it is. So, one consequence of a highly fact-sensitive approach is that it's difficult to predict the outcome of a case for invasion of privacy at the moment. It's difficult to advise clients. But as the number of decided cases increases, some general themes emerge. And the sort of questions that we've had to address is, what difference does it make if the claimant is a celebrity, or the minor child of a celebrity, or a celebrity role model behaving in a way that celebrities are not meant to behave? What difference does it make if it's not just a question of printed words, but also photographs or video material? What difference does it make if the information has been obtained by deception or by harassment? And those are all issues on which we're starting to get some jurisprudence. One point that is quite clear, and this I suspect is a point that is common to the jurisprudence worldwide, is that those who have the least expectation of privacy or of protection for their wounded feelings are politicians. Elected politicians are those who are required to have the thickest skins, because those who put themselves forward for public office must expect and accept public scrutiny and criticism, which is often intemperate and unfair. And there are cases known, I'm sure, to all of you around the world on that. The longer cases in Australia and New Zealand, Sullivan and New York Times in the United States, Lingens at Strasbourg, Reynolds in England, and so on. And another important case at Strasbourg was the case of von Hanover and Germany, which was concerned with the unrelenting pursuit by paparazzi of Princess Caroline of Monaco. And that led to an important judgment by the Strasbourg court, which again emphasized the difference between commenting on those who are genuine in public life and those who are in public life only because the press has decided to turn them into celebrities. The Strasbourg court has even upheld the publication by a doctor of information about the health of the former President of France, Monsieur Mitterrand, on the ground that the grave breach of professional confidentiality involved in that publication was justified by concerns about the health of the head of state. The same sort of approach has been taken towards the chief executives of multinationals, who again are in a position of particular power and influence. Le Canard Enchaîné, the French satirical magazine, got away with publishing the tax return of the chief executive of Renault at a time when Renault was making large numbers of workers redundant, and the British press got away with publishing information about the then chief executive of British Petroleum, because he was said to be using company resources to set up his living partner in business. And then there's a wider and vaguer class of persons who, in Lord Wolf's words, might be expected to produce higher standards of conduct. And Lord Justice Buxton, in another case, said that is no doubt to preserve headmasters and clergymen who, according to taste, might be joined by senior civil servants, surgeons and journalists. I don't quite know why judges and lawyers were accepted from this enumeration. But in all these cases, it's where the element of hypocrisy comes in. Someone being in a position or putting themselves about as being in a position where they're better than other people. And that was indeed an element in the Naomi Campbell case, because not only was she on drugs, she had put about that she was not on drugs, and that in that way she was better than other celebrity supermodels. She was a world-famous celebrity, and it's with those that the popular media are most concerned: film stars, pop stars, footballers, other transient people who for 15 minutes at least are famous for being famous. But Lord Hoffman, in the Naomi Campbell case, did express the view that even super celebrities may have some right to privacy and it should not be exposed relentlessly to every detail of their public life being exposed. Muckraking is undoubtedly a long-standing and salutary function of the press and other media. But once the exposure of bad behaviour moves out of the sphere of political and public life, it's difficult to justify, if it ever was, every or any invasion of privacy on the basis of the well-known saying that there's no confidence in iniquity. In other words, if you find something wrong going on, you have a complete right to expose it. If the exposure of iniquity amounts to the sensational disclosure of aberrant sexual conduct, accompanied by prurient details and possibly photographs or videos as well, it may well be that at that point the public interest defence fails. And we've had many cases in the UK to do with footballers who, because of their wealth and fame, seem to particularly prone to get into casual sexual encounters with ladies who then sell the stories to the press. And there's a fairly mixed bag of results on that. Sometimes they got injunctions. One got an ex parte injunction which was then discharged because on mature consideration it seemed he was much more concerned about protecting his commercial interests, that is being afraid of losing his contracts for promotions rather than actually protecting the private life of himself and his wife. The most striking case of all, and I'm going to finish with this because I'm running out of time, is of course the case of Max Mosley, the president of the International Motor Racing Federation, who was exposed in the most prurient detail by the News of the World for his attendance at what he called a party, and the newspaper called a sadomasochistic Nazi orgy. In fact, his case was successful, partly, but maybe not entirely, because the News of the World star witness failed to turn up at trial, possibly because the News of the World tried to cut down her fee. But anyway, that's not that. But Mr. Justice Eadie, who has now become a considerable hate figure of the British media, because he has been one of the leaders in saying that even celebrities are entitled to privacy, and even celebrities behaving what most people would regard as in a fairly shocking and surprising way, like going to flagellation parties, are entitled to privacy. And Mr. Mosley got £60,000, and believe it or not, he's taking his case to Thursday because he regarded that as an insufficient vindication of his right to privacy. It's a very developing law. I could go on, but I have vowed not to exceed my time. So thank you for listening, and I'm sorry I haven't quite got to the end of my presentation.
Thank you, Lord Walker. After a very, very interesting, and if I may say so, a mildly provocative presentation, which every presentation on privacy is bound to be. The matter is thrown open to the House for interactive comments and questions.
Could I just add a footnote to Robert Walker's account? First of all, I think that judges here would be interested to know that the British Parliament has recently abolished criminal libel, seditious libel, obscene libel, and blasphemous libel, all of which are, of course, in your penal code. But we abolished them by statute, I'm happy to say. Blasphemous libel only surviving for the moment in Northern Ireland. Second point is that in the Naomi Campbell case that Lord Walker mentioned, last week the European Court of Human Rights held that success fees, this is an abusive thing allowing lawyers like us to uplift our fees, especially in these privacy cases. They held that the success fees in the Naomi Campbell case had a severe chilling effect on free speech, and therefore there needs to be a change in that, which I'm sure will happen. Thirdly, in the Max Mosley case, he is asking the Strasbourg court to rule that before somebody intends to invade someone's private life, they must give notice to the potential victim, so that the victim can seek an injunction to stop the invasion. That is a position that at the moment obtains in Russia, the Ukraine, Moldova, Poland, and Lithuania, but not in any common law country. And if that were to find favour with the court, it would obviously impose prior restraints. But the argument from Mosley is that if you don't do that, how can you protect privacy properly, preventatively? And the last point, and perhaps the most interesting in a way, is that the current government have picked up my private member's bill on defamation reform and are at this moment developing what I think will be an astonishingly creative and far-reaching statute to be published in draft form in March and then looked at and probably actually enacted not till the year after next, slowly and properly. That bill will take the 400 years of case law going back to the ecclesiastical courts and the Star Chamber and beyond, and the 19th century law, and will in some ways create some principles which will deal with some of the greatest anomalies of libel law. It won't deal with privacy, which of course is another matter that Lord Walker said. So Lord Walker's talk is engaging a lot of very topical matters for us, and I think that some of them have implications elsewhere. And the final thing I'd say is on New York Times and Sullivan, our courts have not done what the Supreme Court of the United States did and adopted the public figure test, which is not a rational test, since it includes baseball coaches as though they were politicians or ministers. Instead, our House of Lords, in a case called Derbyshire, held that a government body cannot use libel law, but must use malicious falsehood, the same really as the Sullivan rule. And our law lords looked at the South African case, East Bourbon, in 1940, where that court, without any Bill of Rights, decided that a railway company shouldn't use libel law. But what we have not done is to say that the Sullivan Rule applies beyond government bodies. However, unlike the United States, our courts have very sensibly capped libel damages, insisting in Elton John's case and Esther Ranson's case that damages